Council, if you need a bit of time to confer with one another, we can adjourn for a few minutes so that we can talk about this. It's critical. It's critical in the sense that we need to make progress here. And if we cannot make progress, at least we have to understand that it is something beyond our control, at least as a panel. But if the challenges are with the evidence leaders, it will be understood as such. So that's why it is important that you and your team should seriously consider what is possible in relation to calling other witnesses to make some progress. It cannot be seen to be, this matter was postponed for a month, almost a month in December. I don't want to go back there, but so much time has gone. We don't have much time now. And I really wish that all of us must work towards progress. So if it is possible, we should continue. If it is not possible, as you would tell us, you will let us know. That's why I would like you to have much time to consider all possibilities so that we can make progress. Do you need time to confer and discuss this matter in relation to the Mdluli matter, or you have finalized your discussion?
Sorry, we need time, Madam Chair. We'll request then a short adjournment just to finalize that aspect in our response to that.
Before you may switch off. Before we hear Advocate Nkabinde, my sister has a question.
Thank you, Chair. Advocate Skosana, the first reason why you are seeking an adjournment is for the panel to afford you the opportunity to bring an application to this panel which seeks to address the issue of the potential conflict of interest. Am I correct?
Yes, I said so, yes.
You said so, and that is the case?
Yes.
Right. Now, whatever the grounds that you may bring to the attention of the panel, maybe let me withdraw that question and ask this one first. When you make this application, specifically with the intention to bring the issue of conflict of interest to the panel, what is the ultimate goal? Is the ultimate goal intertwined with the question of funding legal representatives for Advocate Batohi, or are they divorced from each other? Of importance to me is to just understand as to whether this issue of bringing the application to show us the conflict of interest, is it being brought with the ultimate view or ultimate intention of addressing the issue of funding Advocate Batohi's personal legal representation, or what is the position?
Well, perhaps to say it is, maybe I didn't articulate it as I should. The issue that will require an opportunity to address the answer may be yes and no, because it involves, yes, it might involve the issue of funding, but essentially as to whether the NPA legal team is or will experience that conflict of interest. And it's not to tell the panel whether or not there's a conflict of interest. The question, the ultimate question, is of course whether Advocate Batohi can receive that legal advice.
I'm trying to ascertain as to what the first question is meant to address. So what you are saying is that that issue of conflict of interest, that application concerning the conflict of interest, is made to obtain what information whether Advocate Hali may consult or advise Advocate Batohi or not. Is that the aim? And correct me if I'm wrong, so that we save time.
Well, it's to establish whether there is, in fact, that's why we refer to it as potential conflict of interest, whether there is, in fact, conflict of interest. There may not be, in which event then Advocate Hali can consider to provide that legal counsel.
Okay. I'll ask again. Does it have to do anything to do with the funding of Advocate Batohi for her personal legal advice or not? Or is it not related at all?
Well, it's related to some extent and not related in others.
Much as I know you have not as yet put pen to paper, but I think it will help us just to understand as to whether information that you will be bringing to us as the panel when that application is launched, whether that information will be information that has already been shared with the Solicitor General and the Minister when the initial application and appeal were done, or is it information that is totally new? And let me inform you as to why I'm asking this. I wouldn't want us to get involved in a toing and froing with the Minister and the State Attorney and so forth. I just want to understand that. Is it something that is looking to also paving the way in that direction? Or is it something that has already been shared and we are now being brought into a better light of what is already known by the State Attorney, the Department of Justice? Thank you.
Well, what I can say is that we as evidence leaders, are not privy to that information. We don't have that information. Our attorney is Mr. Sibele Meza, who is a different attorney from the attorney that briefs the NPA legal team. I think that information may well have been in their possession, but it's not in possession of our attorney, Mr. Sibele Meza. So we don't have information in that regard.
Advocate Skosana, that information I would have thought that during the discussions as teams now, when you make preparation or formulate intentions on what other avenue to pursue or not to pursue, you would have engaged even in the discussion. I think the chairperson did ask about whether you are privy to the information or not, and you did say that you were not privy to the information. There was a long break in between. And as you were sitting there as teams, either individually or collectively, certain thoughts came to mind about how to approach this. Did it not occur to you to try and get information so that we know that when we adjourn here, we are likely to be facing completely new information from the information that the department does have already, or whether it will be amplified information that has already been presented before the Department of Justice. Did you try to establish as to that case? Because remember that you argued for some time about this issue, about the interest of Advocate Batohi and so forth, and how the application failed at a initial level and up to appeals level. But then you don't know what had been said. Did it not perhaps cross your mind to try and source that information from even Advocate Sibele?
Well, all I know is that Advocate Sibele does not have. I tried to check that, and I established that it doesn't have that information. And the attorney for the NPA legal team is not here, and so far we could not get hold of him. I think one has to also consider that information might also be privileged information that cannot just be acquired as easy as that. Information, I guess you're asking me about in relation to what was the appeal to the minister and what was asked to the Solicitor General.
Yes, you do not know for sure whether the information is privileged or not. You say it may be privileged information. You have not established as to whether the information is privileged or not. Am I correct?
Yes, yes.
You have not established.
Yeah.
So it may or it may not be privileged.
Yes.
Thank you.
As regards the two issues that you raised, the potential conflict of interest, you will seek a specific relief, I suppose, in relation to each one of them. Possible conflict of interest in your application because it's an issue. The second one, challenges as regards the witnesses, you will seek a specific relief in your notice of motion. As regards the first, if your information, I'm just thinking aloud, if the information you are going to establish is going to raise new facts that were not brought before the minister or even before the Solicitor General, are we the proper forum to consider whatever relief you'll be seeking before us? If totally new information which ordinarily ought to have been brought to the attention of the minister but was not, and it emerges now, are we the right forum, given that the decision in relation to the core issue is an executive, or rather entails an executive decision? Elaborate, Counsel, because ultimately you'll ask us to grant you some form of an order or a direction. But if the information you are going to gather appears to be an information that ought to have been presented to the minister when making a decision, are we the right forum to even be given that information to make what decision, if the decision falls within the prerogative of the executive?
Thank you, Madam Chair.
Oh, I beg your pardon. I beg your pardon. I will repeat myself very briefly. I beg your pardon, gentlemen. My question is, yes, Counsel. I'm trying to think aloud because you do not want to anticipate an application in respect of which an ineffective relief is going to be sought, whereupon we don't even have a power to grant that kind of a relief. So the long and short of this question is, if the information that is not before you, that you are going to establish, is the information that ought to have been presented to the Solicitor General in the first place, secondly to the Minister on appeal, is found, will we be the right forum to even consider that information, because the decision is that of an executive, the Minister herself?
Thank you, Madam Chair. I think the application that we are bringing is essentially to ask for an opportunity for that question to be considered, not for the panel to consider that information as such, which was brought before the Minister and so on. What at this stage, I think the application is to obtain permission from the panel to adjourn the proceedings until Monday, so that that issue can be resolved. And we think whether the information is already before the Minister or was not placed before the Minister will appear. One should remember that also the question of her getting legal counsel may get to a point where she has to obtain it privately, in other words, using her own, from her own pocket or from her own funds. We are saying, as evidence leaders, that opportunity that we are requesting should include that, considering all the questions, and when we return, it will be that she has obtained that legal advisor, whether from a private legal practitioner or from one that is funded by the state.
No, my question is different. My question is, pardon again, whatever you're going to establish counsel, you don't have information at the moment. But we know one of the issues relate to the potential conflict of interest, as you say, which impacts on the very request that was initially made to the Solicitor General and the Minister. Am I correct?
Issues were before the Solicitor and the Minister, yes.
No. My point is, and I'll repeat myself, the very issue that you have raised, the potential conflict of interest, impacts on the issue relating to Advocate Batohi's request to the Minister, ultimately.
Yes, Madam.
Is that correct?
It is correct, yes.
It is correct. Now, but the point I was raising with you, if it is correct, and this very information you are going to establish in due course was not brought before the Minister, are we the right forum even to know anything about that information in the first place? Because we don't have such a power which vests in the Minister to decide whether yes or no she could be afforded a legal representative. I'm looking at the question of relief, basically, that you can make an application, but when you make an application based on the facts that you are going to establish, if those facts are new facts and were not brought before the Minister, shouldn't you go back to the Minister and say, here are new facts that we didn't present to you, which may convince you as you exercise your executive decision to enable Advocate Batohi to be legally represented at the personal level. Basically, this is what I'm saying. The panel doesn't have, you're not seized with such a power. Even if you come up with new information, to what extent does that information impact on the ministerial executive decision making?
Well, to answer the question, I think the panel doesn't need that power. And the panel is not asked to exercise that authority to decide whether Advocate Batohi should be funded or not. The minister has already decided, as I understand it, the minister has already decided that she already has a legal team which is funded by the state, that's what the minister has decided. Now, the opportunity that we ask for is for the determination of whether there is a conflict of interest for that legal counsel to be provided by this legal team, the NPA legal team. And it may be that there is no conflict of interest. Then the NPA legal team will complete its task and grant and provide that legal counsel. If there is a conflict of interest, then the issue will have to be then resolved further, which I have already indicated may require that she now must obtain advice from a private legal firm.
So if I understand you correctly, and correct me if I'm wrong, what you seek to present to us is submissions or evidence to prove that there is a conflict. Do I understand you correctly, Counsel?
I'm not sure if I understand you, Madam Chair, yes.
The application that you The application you seek to launch deals in the first place with a potential conflict of interest. Now, if it is established from the facts that you are going to gather that there is indeed a conflict of interest, a matter which probably was not brought to the attention of the minister, shouldn't the matter then be taken to the minister, who has a decision, who has the power to make the decision regarding Advocate Batohi's legal representation?
Well, Madam Chair, to decide whether, I'm not sure if the minister is to decide whether there's a conflict of interest or not.
No. If you present new evidence to her,
Yeah.
where in your letter or your memo you say to the minister, Minister, that which was presented to do previously, following on what information you're going to be given, did not encompass this information that shows or reveals a potential conflict of interest. We are therefore urging you to consider this new information that then impacts on your earlier decision when you reflect on the new evidence that proves a potential conflict of interest. Do you understand what I'm saying?
Yes. Yeah.
Therefore, if that can be the case, why is it that it is us who must make a decision on the conflict of interest? Because it's just a factual matter. It's either you establish a conflict and then you go back to the minister, and the minister decide on whether to reflect on her earlier decision. I think that's to start with the state attorney, Solicitor General. He may be persuaded. Then he can say to the minister, yes, I think Advocate Batohi deserves a legal team to represent her. The minister may also agree. My point is, why should such an application be brought to us?
Well, Madam Chair, let me start off by saying that may well be so, that an application may be brought before the Minister or the Solicitor General to say there are additional facts which establish a conflict of interest and therefore reconsider this application. But before we get to that point, first, we need to establish, or it must be established, that there is in fact a conflict of interest. Now, we haven't, in our submission, we haven't passed that point. We are asking for an opportunity to establish that, and that can only be established during the period that we are asking an adjournment for, whether there is a conflict of interest. And only after that can we go back to the minister, if that's a decision to be made, to say there are additional facts which establish that there's a conflict of interest in the team that you have directed must give advice.
Yes, I now understand. That's why we went this route of asking you questions, because you started at the application and we're talking about time frames as to when you're going to launch the application, when they are going to answer, when you're going to reply, when the written submissions are going to be filed. And we're talking in that context of you saying you seek an indulgence for a matter to be postponed so that you can make an application. And that's why these questions arise, Advocate Skosana. But if you are saying now, it is not an indulgence to apply, but an indulgence to go and ascertain whether there is any information that may prove or disprove a potential conflict of interest with a view to approach the minister. It's a different matter. Am I right?
Yes.
But if the intention is to gather information to prove or disprove conflict of interest, why would you need 7 days to do that exercise? If I understand you correctly, to say you want the inquiry to pause until Monday next week. And I'm asking this question on the background that we are pressed for time. And we've had to write a letter to request an extension and give reasons for our request. But then we start on the very first day, we're talking about pausing for 7 days. Isn't that counterproductive?
Yeah, I understand, Madam Malloy, SC, from where you come from, but I think, I said earlier on we will reveal this in more detail, but perhaps in the interest, and I understand the time frames and the time constraints, we must understand also the changes that are happening within the office of the NDPP. And I think that actually in a matter of a week, I think there will be a new NDPP. One should remember that the decisions to be made on behalf of the NPA would normally involve the NDPP. I don't know if you, I hope we all follow with these many acronyms, but the decision has to be made by the NDPP. Now, the new NDPP will come in.
Which decision are you talking about now?
The decisions that
I
may...
beg your pardon. You say decision has to be made by the new NDPP. Which decision?
Well, when we speak about when we speak about the potential conflict of interest, we're speaking about the potential conflict between the NPA as an institution and Advocate Batohi, who is currently the NDPP. So, and as an NDPP, she also makes decisions on behalf of the NPA. And we all know that in a matter of a few days, there will be a new person in that post. So
the postponement for a week will enable the new NDPP then to be seized with the matter, basically, because Advocate Batohi will not be there anymore by beginning of February, which is about next week.
Yes. Yeah, I think I've said much. The Advocate Batohi cannot be involved at this stage in that decision, which may have a conflict with her personal interest in the office of the NDPP. And at the same time, she is making decisions as the sitting NDPP on behalf of the NPA. So it's convoluted, but what we are trying to resolve are all those issues, and which we are just disclosing those in order to enlighten the panel on the issues that we have to deal with and that we're requiring an opportunity to resolve. That is not, we are mindful of the time that we have as an inquiry, but at the same time, those are serious issues that actually warrant proper consideration and may warrant the granting of this postponement. As we say, I'm merely elaborating and elucidating without paper at the moment. We will provide proper affidavit in that respect and also submissions.
It's a long answer to my simple question, Council. I was asking you, the postponement would enable the new NDPP to be seized with the matter. As you said, I mean, if you postpone for a week, that's the end of the period of Advocate Batohi. Then she cannot decide. Therefore, the new NDPP then will be seized with whatever decision-making power, including this very issue. Correct?
Yes, Madam Chair. Just that I elaborated, but yes, the answer is yes.
In fact, as you have said, and I hope I understood you correctly, we are not adjourning that you apply. If I understood your submissions, you are not going to apply. You are going to consider whether there is any evidence, new evidence, if I may say, concerning the potential conflict of interest that was not brought to the attention of the minister. Am I getting it right?
I'm not sure if it's correct,
yes,
Madam Chair.
You see, all these things that discuss revolves around the issue of whether Advocate Batohi should be afforded legal representation, isn't it?
Yes.
So if the minister could have been given all the information that you're going to establish, maybe which was not before her, it means she must then be approached and say, reconsider your decision in light of this new information. Am I right in my understanding?
Yes, Madam Chair, I think partly because that decision would be to say, we're bringing this additional information, which was not before the minister, to say, now, grant permission that she be funded to employ another team other than the NPA legal team. Yet, at the same time, we are saying we still need to establish whether there is a conflict of interest. In other words, if there isn't, then the NPA legal team can continue to grant that advice.
Yes, that's what I'm saying.
Yes.
That's what I'm saying. I
Thank
just
you.
want to ascertain whether you are going to launch an application, an interlocutory application, or whether you need the time, a week, to go and consider all these things that you are raising. And if you find this information, then where to go to?
Well, Madam Chair, if we are able to secure that time, that opportunity, without bringing the application, a formal application, I think we'll all and subject to what Advocate Batohi may say, then we'll all be relieved from bringing that application and asking the panel to make a ruling on it. But Madam Chair, you have correctly, I think you've kept it so nicely and correctly that those are all the issues that, as evidence leaders, have taken into account, and which we thought we need to put it on affidavit formally in order to support this request for adjournment.
You see, Council, unfortunately, ordinarily, when you seek indulgence, a postponement, you apply. The reason why we ask you questions because you have not filed a proper application for a postponement for a week. And we need to understand why you are entitled to be granted that kind of a request. Because a postponement is not there for the taking. You have to explain to us, given the circumstances that we have elaborated on, the time frames and the time expended already, why is it that you should be given this, the request that you seek? Because we don't have anything in writing. So we have to ask you questions to determine whether indeed we can grant you the indulgence that you are seeking. So we are not just asking questions for the sake of asking. We want to understand where you are going to and what you seek to achieve.
Thank you, Madam Chair. I think I understand, and I have no difficulty in being asked as many questions as possible. I think I've been in that situation before, if not worse, in the past. So I think I understand perfectly. I have no difficulty being asked as many questions.
I am tempted to say, Council, lastly, before my sister asks, if we do not proceed with this matter, or as we are minded to do, we may grant you the indulgence. But the indulgence will be coming at the instance of the evidence-leading team, which will cause a delay. So the delay will be at your door as evidence leaders. Evidence leaders comprised of a team of 4 advocates. And we find ourselves where we are today. So I just want to place that on record, that the delay should not be placed at the door of the panel because we are all ready to proceed. And we are even trying to look at other avenues. Whilst the issue relating to Advocate Batohi is being attended to, can't we even try, as evidence leaders, to look at the other possibilities of proceeding with other witnesses, the names of whom we have placed on the record? But we are engaging with one another, which something that is actually saying to us, to me at least, we are delaying with this process. I don't sit very comfortably with that kind of a position because time is not on our side. I'll repeat it again and again. We ought to have done better as an inquiry, as evidence-leading team, especially because you are 4 advocates. You have consulted with witnesses, and we're trying to really help you. Let's look at this avenue. So let's consider this. So you must also be seen to be helping us to make progress and not to delay the matter any further.
Thank you. Advocate Rosana, we engage you out of necessity. We fully appreciate that you sell time.
I understand,
Yes.
madam.
Yeah. Right, maybe let me just take off from where the chairperson has left the question, then I'll go to the next one. I would have preferred to do it the other way around, but that's fine. Now, my understanding of your statement when you are asking for a postponement, you say, is that what you are seeking to obtain is a determination whether there is a conflict of interest or not. Now, thus far it would appear that it would be 2 parties involved. It would be the evidence leader advancing whatever argument that has been brought to its attention, and then it would be Advocate Chauke's team also advancing whatever argument it may be. Now, what I first want to know is which side of this question are you? Is it about obtaining a determination that there is in fact conflict, and the other one is opposing that and wanting the panel to find that there is no conflict? Can you just indicate to this panel as to which side? Are you the applicant, or the evidence leaders team is the team that seeks to get a confirmation that indeed there's a conflict of interest, or is it a team that seeks to obtain a finding that says there's no conflict?
Well, the way I understand it is that we are on neither side. We are not on. Well, if there's a conflict, there is a conflict, and the conflict will be between the NPA and Advocate Batohi. And if there is, then that means the legal team cannot advise her.
Thank you. You know, this question, it's a question that I'll say is just been changing colors and sizes and what have you, but it's the same question about the relief sought. Who is seeking which determination? And when you say, well, we are on neither side, what are you doing? Are you going to file, in the event that you come to a conclusion that there has to be an application, are you going to file an affidavit that says we shall abide by the decision? We not seeking any determination as evidence leaders now, because I think I got it wrong. As I was listening to you when you said, what we seek is to obtain is a determination whether there is a conflict of interest or not. Now, from that statement, what came to my mind is that here it means there'll be no less than 2 parties, one contesting for a determination that there is a conflict, and the other contesting against the determination. But I may have been presumptuous and assumed that that would be the case. And it would help us, you as the evidence leader, to just clarify that issue as to, you have made it clear that you are neither for nor against. So what role will you be playing as the legal representative leading the evidence leaders team in this respect?
Yeah, I think, Madam Ramakaka, we are correct that we are not on either side. All we are saying, we're asking that an opportunity be granted for that to happen. The legal team, the NPA legal team, will establish themselves whether there is a conflict of interest. If there is, then they cannot provide the advice. If there isn't, then they'll provide the advice, and the advice, we don't know what advice they will give. It will either, no, don't go back, don't, or it will say, and then we can then, from there, that Advocate Batohi, we are certain now she is not going to return to continue her testimony. And that in that event, what do the evidence leaders do?
Is there a role that you foresee playing? And when I say you, I'm talking about you as a collective. Is there a role that you foresee yourselves playing in this issue of a determination whether there is a conflict or not? And if there is a role that you see yourselves playing, what is that role? Thank you.
Yeah, at this stage, I don't think we really have a role there. The issue is between the NPA and Advocate Batohi as the current NTPP. So all we are waiting for will be an answer. Yes, there is a conflict, yes, or there isn't. And we think with all the information we have, the reasonable time will be up to Monday. And I've indicated that also there would have been a change of hands in the office.
Thank you. Let me then get off that subject. It has been canvassed. I can't say adequately. There may be a need to canvass it further. The question that now I want to go back to is the question of a list of witnesses. Remember, there are two grounds for the application. It's the witnesses' challenges and it's the potential conflict. Now, I'm addressing the issue of the list of witnesses, right?
Yeah, so sorry for interrupting you, madam. I just, that question, I think that's the one where you were saying you're going to grant me an opportunity to confer with my team. Unless it's not related to that, just wanted to.
Yes, I remember that I think it was actually the chair who then indicated that, you may get it, you may have to obtain instructions. And let me then be disciplined and restrain myself from asking you the question that I wanted to ask. I stop here for now. Thank you.
I'm going to make a follow-up on what my sister have asked you. You said you don't see, for now, you don't see yourself, the evidence leaders, playing a role in the issue of conflict of interest. This is between the NPA and Advocate Batohi. Now, are you requesting this period of until Monday on behalf of the NPA and Advocate Batohi? Or you made your own judgment to say we will need this period, they will need this period to deal with the issue?
Well, as evidence leaders, it has been repeatedly said that our duty is to bring evidence before this inquiry. And we have been doing that. Advocate Batohi has been called as a witness by the evidence leaders. And in the process, there were these challenges or difficulties. So we're trying to merely resolve that. And we thought in our own right as evidence leaders, we could bring that application in order to ensure that things proceed in a proper manner. And she is given that opportunity. And we think a reasonable time would be up to Monday, in view of what I've mentioned, what is happening at the moment.
So as a follow-up, it is the evidence leaders who determined this period. And while keeping in mind that you are not going to play any role in the resolution of the whole issue. And you are right. You, as evidence leaders, you are the ones who are driving this process, who must see to it that it comes to an end. And after having raised issues about time frames and everything, and after you having considered that you are not going to take part or to play a role in this issue, do you still insist that you need 7 days to resolve the issue of conflict that is between Advocate Batohi and the NPA? And I will add further, because you now brought in the issue that in next week a new head of office will be taking over. Now we're breaking until Monday. Come Monday, a new head of office is taking over, and I'm wondering if the new head of office would have considered everything and made themselves au fait with this whole inquiry and its issues by Monday, or for the head of office to take a decision whether there is further funding for Advocate Batohi, or Advocate Batohi must get her own private legal funding. It seems like we are trying to kick the can down the line. I don't see the end of this, because come Monday, there will be another issue. There is a new head of office who needs to apply their mind in order to take a decision. I don't expect a person to jump into the office on Monday and decide, okay, no, we are not funding, or no, we are funding. They'll have to weigh the options and to consider that there is an NPA team, and where is the conflict, and what is happening, what has been happening during the initial consultation stages, and all those. And also maybe want to go through the whole record to acclimatize themselves with what is happening. So is this ever going to come to an end? And also, what informed you to request for 7 days? I don't even want to imagine what will happen beyond the 7 days come the new head of office next week. Why? What? Because Advocate Batohi started the process, and rightfully so. She was empowered. She is empowered, actually, not in the past tense. She is still empowered by a statute to deal with this process. So why should it be that we want to postpone, we want to pause until a new head of office comes in, and then deal with the issues thereafter, when we have a process that has started, lawfully so and legally so? I don't want to believe that we are trying to kick the can down the line, down the road. Thank you.
Well, certainly not from our side as evidence leaders. We're not trying to kick the can down the road. one must consider that when you say there is a conflict between the NPA and Advocate Batohi, who do you ask that question? On behalf of the NPA, you have Advocate Batohi, because there has to be a person. NPA is an institution. Now, obviously, you cannot ask that question to Advocate Batohi to give you an answer on behalf of the NPA. And that's in that context that we are saying it is important, and perhaps it may help us to resolve the issue if the new person takes over the office and makes the decision on behalf of the NPA. And may I add also that we have been doing some of the things, and some of the submissions also have been discussed with the NPA legal team, who at this stage, of course, they have no audience in this inquiry. I don't know if the panel still intends to grant them an opportunity to address them, but we also had some discussion with the NPA legal team.
As a follow-up, Chair, Advocate Skosana, shouldn't right from the beginning your submission, shouldn't it have said we want to pause and wait until the new head of office comes in order for the head of office to take a decision? Because we've heard that you want to bring an application to this panel to make a determination. The next thing, if there is new evidence, it needs to go to the minister. And then the third thing, you are not going to play any role. You don't see yourself playing a role. But all I'm saying is, it seems like the crux of this request for a postponement is to allow the new head of office to come in and deal with this issue. Am I correct? Correct me if I'm wrong.
Well, it's an important factor, but it's not the only factor. We have and we intended to put that on paper. There are several reasons which I've divided into two categories, but it's not the only point. It is an important point.
The answers are giving rise to further questions, Advocate Skosana. I thought that a process has started, in respect of which Advocate Batohi approached the Solicitor General and then the Minister. I don't see why the new NDPP comes into the picture. If the information to be established as regards the potential conflict of interest is found, the new NDPP doesn't come into the picture. He doesn't have powers to make any decision whether Advocate Batohi should be given money or not. The matter goes back the same route where it started, back to the Solicitor General with the new evidence, and then the Minister on appeal. So I don't think we should complicate issues here and bring a new NDPP into the picture, because that's going to create a whole problems for us. And I'm just saying there's a matter of guidance. My understanding is that this decision taken by the Solicitor General and then subsequently the Minister, which does not favor Advocate Batohi, may have to be revisited because of this alleged potential conflict of interest. And if indeed, as you receive the information, you find that there is a conflict of interest, then you present it to the Minister, first to the Solicitor General, who may just resolve this issue and say, yes, upon consideration of this new issue, we decide otherwise. If they don't, at the State Attorney, you then approach the Minister with this new information. I don't see how the new NDPP comes into the picture. Where do we start? Where do we end with this whole thing? So I'm raising it so that we don't lose sight of the fact that a process has started, and we may have to go back to that same process without necessarily involving the new NDPP. Because the decision is that of the Solicitor General and the Minister, as I understand it. So I thought that you need this postponement to consider that. You said that you are not making an application. So if you need time to go and make that determination, shouldn't 2 days be enough for you to ascertain that the Solicitor General is here? Then you can then decide what procedural steps as regard the decision you seek finally are going to be. Do you really need a whole week to do that? And that's the point my sister was raising. Why do we need a week? Because if you had applied, we will be having facts in front of us. That's why we are asking this question. Why do you need a week? A full week, for that matter.
Well, Madam Chair, it's because of the reasons and the other grounds that we put forward, and we seek to put forward in that application. We have mentioned, and I said it's two categories. It's about the issue of the conflict or potential conflict of interest. There's also the issue of witnesses, which we also seek an opportunity to explain by way of affidavit. And the question that has been raised about the other set of witnesses relating to the Mdluli case, I will need an opportunity there to confer before I respond to that.
Yes. The question of witnesses, we had indicated that we'll give you time to confer with your colleagues, because if we are agreed that the process to follow, if you're mandated to grant you the 7 days, or maybe even less than 7 days, is to make a determination on evidence as regard to potential conflict of interest. Then the other issue as regard the witnesses, we said, if it is possible then to proceed with the Mdluli matter, then consult with or confer with your colleagues and determine whether the witnesses who have been lined up can be called. Then we can proceed. Whilst we are dealing with the Katomena issue, the potential conflict, the witnesses that are giving you challenges. So I suppose we go back where we were, that we will afford you an opportunity to then confer with your colleagues to discuss that second matter. Can't we proceed with the Mdluli matter? Those witnesses would have been lined up. You'll have a time, I beg your pardon, I'm talking?
I beg your pardon, Madam Chair, just a paper that I wanted to understand.
You'll have regard to your paper. I'm saying, I'm just trying to line up the process. If you are agreed, then we can pause, and then you properly consult with your colleagues as regard the second issue, and so far as the Mdluli matter is concerned. Maybe we can start whilst you are dealing with the other issues.
We will respond.
Yeah.
We will respond to
In
that.
due course.
And Madam Chair, while you're on it, the note I've received is a request that Advocate Batohi be excused for the day. That's what disturbed me a few minutes ago.
Thank you, Chair.
Yeah, before you proceed, Advocate Batohi has just asked that she be excused. I think we can allow that. We are engaging with one another here, so Advocate Batohi can be excused. Is it correct?
Yes, but we have to agree about who informed her about the next date. Because now she's been
Yes.
because we cannot determine if it is
Yes. My sister raises a point someone will have to tell her, if you decide that we'll postpone this matter for a week or for less than a week, someone has to give her a date. I suppose yourself, as the evidence leader, you brought her here. I think it would be proper to hear from you. So I don't foresee any difficulties with you conveying to Advocate Batohi about our final decision in relation to the postponement.
Yes, we'll do so, Madam Chair.
In that event, Advocate Batohi, we have received your request. You are excused for now. Thank you.
Advocate Skosan, I'm asking for a question. I'm asking a question which is capable of being asked in or answered in clear and unequivocal terms. And if it means you get information from your instructing attorney, you can do so. And understand one thing, I will not try to even tempt you or provoke you to come up with the information that was placed before the minister. I'm not looking for the substance of the information when the application was done. All I am asking for is for you, if by now you still do not know, for you to find out from your instructing attorney as to whether the question of potential conflict interest ever served before the SG, I want to call it in full. That SG, what do you call? Solicitor General. Thank you, senior citizens on the bench. Solicitor General, or even the minister. Just to establish that from him as your attorney of record. So you see, you understand when I say it's simple and capable of a clear and unequivocal answer. Because it's either it's going to be yes, it had been placed, or no, it wasn't placed. The issue of potential conflict of interest when Advocate Batohi applied for funding from the department.
Yes, I will ascertain that.
Thank you, Advocate. Are you done, madam?
Yes, I'm done. Thank you, Chair.
Thank you. Thank you, Reskosana. Advocate Toby.
Madam Chair, we will oppose the application for postponement, but we do not think that we can oppose the fact that they want to apply. So we think they should be given a chance to apply, but we will oppose it on the merits. There is a lot to be said, but I think it should wait until we see the content of the application. If they want to bring the application for consideration this week, we would propose that they try and launch it by tomorrow at 5 p.m. and give us a chance to answer it by Wednesday at 5 p.m. It can be set down for argument on Thursday at 9, and they can file a reply at the same time as the matter is argued. And that will give the panel the Friday to make a determination on whether the postponement is granted or not. Now, arguably, Madam Chair, it can be asked, well, what's the point of this exercise, because they only want an adjournment until Monday. But we think it's nevertheless important to put it on oath what the problem is, why the matter cannot proceed, bearing in mind the public interest that underpins these proceedings. It's the first time we've heard that there are problems with witnesses, but I also don't want to speak about that because my learned friend has not explained the nature of those problems, and maybe he is waiting until someone qualified goes under oath on those. But we will see what they say in those. The question about Advocate Batohi, I think I just want to say maybe two things. One is that we must not forget that she has walked out of the proceedings without the consent of the panel. The panel should not create the impression that you can reward the delinquent behavior of a witness who walks out and then makes an application while outside. She walked out on the 15th of December. Today she was present, but even today she elected not to give evidence. In both of those instances, those were unilateral decisions which did not have the permission of the panel. So although we are debating the question of her access to legal representation, the context must not be forgotten that we are dealing with a witness who's taken the law into her own hands and disregarded the authority of the panel. That's the first contextual matter that is really critical there. The second issue around the unilateral action of Advocate Batohi is the impact that it has on my client. My client is on suspension. He believes that his suspension is wrongful because he believes that the charges are without any foundation. Whether he's right or not, he is entitled to a speedy determination of that question. The election of Advocate Batohi to unilaterally abscond from the proceedings has already taken a month and a week from these proceedings. So that is why we will be opposing the request for the adjournment. If our learned friends are ready on Monday to call the next witness, we would of course be pleased and we will be ready to cross-examine them as soon as possible. But I understand that that question also depends on the challenges they will be outlining on paper. And that's why it's premature to make commentary on that issue. So in summary, Madam Chair, we are not standing on the way. We will play along and cooperate. And we've got a proposal around the timetable. Thank you.
Yes, thank you, Advocate Nkabinde. But you have to remember that Advocate Skosana seemed to have changed tack. Initially, he sought an adjournment so that they could apply a substantive application. Subsequently, he says what they need is time to go and consult and make a determination whether there is a conflict. Meaning, he's doing away with an application, and once they find that there's a conflict, then they will take the next step. That's why the engagement as to then who is the right decision maker if they find that there is a conflict. What is the impact of that finding or determination as they will find when they assess their facts or evidence? And I said to him, this is not a forum to make a decision eventually. It's an executive decision. And I would like to hear from you. The process kick-started with the Solicitor General. It ended with the Minister on Appeal. Now, if they have to start the process de novo on the basis that new evidence has surfaced which impacts on that very decision. They must go the same route. And the point we make now is the same route, is that determination, establishing those facts, require a week. We at the moment, tentatively, we think a week is too long. They are not bringing an application, if my understanding is correct. Because if they bring an application, the question is, what relief? And I'll be very much interested on the relief they seek from us. If you don't have the power to decide on whether Advocate Batohi should be given funding or a separate legal representative or not. It's an executive decision, not the decision of the panel. That's why they have to go back the same route. But do they need a week to do that? That's the question.
Madam Chair, the answer is no, they don't need a week to do that. They need a day. There are substantive answers to it. Advocate Batohi is not entitled to state funding. State funding is discretionary. She has no right to state funding. The panel has no power to order the minister to give Advocate Batohi her own funding. Advocate Batohi is also not entitled to consult with an advocate in the middle of her cross-examination. That is in violation of the rules of the bar. So the relief that she wants is against the law of this country. But it's premature to engage in that argument until we see the application that will be brought. The second...
No application. You won't see any application.
Well, unless I misunderstood my learned friend, I thought they will still bring an application because he says it's two-pronged. One, the first prong is the conflict issue. The second prong is the witness readiness issue. So an application is coming, as I understand. But insofar as the first prong to the issue, she has absolutely no right to any of the things she's asking for. Now, you cannot ask a postponement of an inquiry in order to achieve things you are not entitled to by law. So, but they still want an adjournment so that they can work through the difficulties they are experiencing with witnesses, something I sympathize with until I see what exactly the challenges are. But at the moment, I don't know, and maybe my learned friend also doesn't know, and we will see what they say. So it's only in that context that I say a timetable is still indicated, because we may have to deal with the problem that if you were to say to them, now, Madam Chair, it's 2:15, call your next witness, they won't be able to call anyone. And so that's why they want a postponement in order to sort out that problem, which I understand, and that's the timetable I was really addressing myself towards. If he doesn't want to bring an application in relation to the first issue, that's fine, but I understand him to still persist with it if I'm fair to his submission.
Yes, thank you. And in fairness to the evidence-leading team, we have given them a leeway to confer as regards the issue of witnesses, which would ordinarily have necessitated that application, as you say. So we will have to await their conference. We'll adjourn and enable them to talk, to establish whether we can start with any of the witnesses in relation to the Mdluli matter, at least, so that we don't waste time. Whilst the issue regarding the potential conflict of interest is being considered by them without bringing an application. And of course, that issue, if it is so well established, you then land on the desk of the Solicitor General and then the Minister. It has got nothing to do with this inquiry. And if the Minister is persuaded, then she will decide as persuaded. Or if the Solicitor General decides favorably, he will decide. These are public funds. We don't get involved there. If the Minister and the Solicitor General has money to engage further counsel, further set of advocate because of the alleged conflict of interest. That's their decision. But what bears heavily on us is the delay. We should be able to proceed, at least with some of the witnesses. Do you agree?
We agree entirely. There's something to be said about the delay. It's important to get moving with the inquiry. Advocate Chauke is also entitled to know the outcome. But this is a case also of immense public importance. I don't know of any inquiry like this where the question of a prosecutor not prosecuting despite the evidence and prosecuting without evidence has ever been tested in this country. And the accusation is made by a person no less than the NDPP. And it is made against a DPP. So this is a matter of immense importance. And the facts that have been uncovered so far are also troubling facts. So the public is also entitled to an outcome. I always think, Madam Chair, since the evidence in this case of the mother of KwaZindlovu, she is entitled to know what is the truth about the killing of her son. And the delays are not helping her to get resolution to what happened to her son.
Without elaborating much on the issue of public interest, it's also a matter of legality when there's no finality to issues of such national importance. Put aside the issues of budget. A lot of money is expended on this inquiry, and it has to be brought to an end as soon as possible. So there's just so much at stake. It cannot just be issues of postponing for the sake of postponing. That's why we're engaging with counsel. Just understand, why is it that this matter has to be postponed further? It was postponed last year. We lost more than a month. Now we're going to lose a week. That's why we're engaging with counsel to understand the basis for postponing for a week. If we can indulge them, because I think in fairness to them, they need to confer with the Solicitor General, Advocate Nkabinde Measure. I've seen your correspondence. They must consult with you, sir. But a week is too much. We need to finalize this matter, at least make some progress. So I think, Advocate Nkabinde, we will take an adjournment, unless my sisters would like to ask something. We will adjourn for, how long would we need, Advocate Skosana? 15 minutes? 15 minutes or so? And you will let us know once you have discussed. You know what our position is. I think we have repeated ourselves again and again. And please, when you come back to us, assist us, because we don't see ourselves going home to wait for next Monday with an application just for you to go and talk. So, Advocate Nkabinde, thank you. I think, in fairness, we will, after my sister has asked, and if there's any further question from my sister on the left, we will then adjourn for 15 minutes to enable Advocate Skosana and team to talk. And when you are ready, we will come back. You will then have to indicate whether, in the context of the issues of Mdluli matter, whether we can start either on Wednesday to notify the witness who will come, and we continue. So don't let us know. Yes.
I just wanted to ask you to consider this. Remember, we adjourned on the 15th of December, and on the day of the adjournment, we knew that Advocate Batohi is going to request her own personal representation. So that's one thing that you need to consider, and also consider when did the minister take the final decision and what happened thereafter. And also the fact that you had a framework, you had an inclination of the witnesses that you're going to call. And I don't want to believe that they all dropped you on Friday, this past Friday. So while you are conferring, please try to give us as much information as you can so that we understand what happened. I don't think they had a meeting on Friday and decided, oh, the inquiry is sitting on Monday, we are all not going. So please take us along on this a month and a week that we've been waiting, and while time is ticking. What happened in the process, and what steps did you take to try and mitigate, to try and assist this inquiry to be finalized within the set time frames? Thank you. Thank you, Chair.
Yes. Hosanna, I see you're pressing. Yes.
No, I just wanted to confirm that we will do our best to bring that information.
Thank you, sir. Council will take an adjournment for 15 minutes until until 3 o'clock. You will send our researcher to call us. Thank you.